in listen-only mode.
Good afternoon everyone, and welcome to CCIQ's webinar presentation. It's our pleasure to be able to talk with you today about CCIQ's Workplace Relations Blueprint, entitled Workplace Relations Framework for Modern Businesses. My name is Michael McGregor and my background is in business management and international relations. In the advocacy team, I'm responsible for regional economic policy and online communication. I'm joined today by my colleague Claire East, who is the Workplace Relations Advisor at CCIQ. She has primary responsibility for CCIQ's Workplace Relations and Skills and Education policy. Welcome, Claire.
Thank you, Michael, and welcome to everyone who is participating today. We really hope that you find the session interesting and informative.
So, just to get started, on your screen are details of CCIQ's Employer Assistance Line. If you do have any questions about your own workplace arrangements, don't forget to make use of this great benefit. And if you're not yet a CCIQ member, it's easy to join on the CCIQ website. So, just a couple of housekeeping rules and tips to get the most out of your webinar presentation today. The presentation will run for around 25 minutes, where Claire will discuss the Workplace Relations Blueprint with a key focus on CCIQ's findings. I'd also encourage our listeners to send through any questions that they have in the dialogue box on your screen. We will try and answer as many as possible throughout the presentation and at the conclusion during a 15-minute Q&A session. After the webinar today, you will also receive a copy of the webinar recording, a presentation and electronic copy of the blueprint, so you can keep them on hand for future reference. You can expect this to be in your email in roughly 2 to 3 days. So without any further ado, let's get started. Claire, I understand the Workplace Relations Blueprint is hot off the press?
Yes, as of just last week, in fact. We launched the blueprint last Tuesday in Brisbane with the Queensland Attorney General in front of an audience of small and medium business owners and managers. For our part, Michael, all of us at CCIQ, and you included probably, are very proud of the blueprint. We think it's a much-needed consolidated document of all the key issues facing SMEs all over Queensland that we can present to the federal government.
Claire, CCIQ has been hearing about the difficulties that employers have been experiencing under the Fair Work Act for some time now.
Michael, I can tell you that since it was introduced in 2009 and the practical effects of the new regime could be felt, Queensland employers have been telling us about all sorts of problems that they have encountered under Fair Work.
And that might explain some of the poll results that we can see up on our screen.
I think the results really do speak for themselves. You can see that nearly 2/3 of Queensland businesses polled by CCIQ believe that the federal government has not gotten the balance right when it comes to the Fair Work Act. We can also see that nearly 60% of businesses said that the Fair Work Act has increased the regulatory burden on their business.
And is it correct to say that small and medium businesses are often least capable of taking on this regulatory burden?
Yeah, I think it is fairly well established that this is the case. It's unsurprising that more than 2/3 of employers polled felt that the Fair Work Act just doesn't take account of the special circumstances of small and medium businesses, a key aspect of which is a lower capacity to meet increasing compliance burdens. Michael, to make things worse, the federal government wants to add to this burden.
So you're saying that there are more proposed changes to the Fair Work Act that may negatively impact on small and medium businesses?
Unfortunately, that is the case. The federal government has announced that the right to request flexible working hours held by new mothers will be expanded to a range of other classes of employee. Employers will be required to consult with staff over roster changes, and a new modern awards objective will be added, requiring additional remuneration for those engaged in so-called insecure work, or as we might know it, casual work.
Yes, well, let's move on. Well, Claire, there are obviously a lot of views out there on workplace relations and what our laws in this area should look like. It sounds like the CCIQ WR Blueprint is trying to unite some of those voices in order to obtain, I suppose, positive outcomes.
Yeah, Michael, I think it would be most apt to describe the blueprint as outcomes focused. While the federal government may not be listening to Queensland's small and medium businesses, CCIQ is. We think that owning a business should really be a rewarding experience experience, and we believe that employers should be encouraged to hire, and indeed the state and federal economy depends on them having the confidence to do so. So this is why CCIQ has taken charge of the workplace relations agenda in order to compel politicians in Canberra to recognise the importance of workplace relations to small and medium businesses in Queensland and indeed the rest of the country.
Thanks, Claire. Well, let's get into some of the details of the blueprint. Can you tell us how you went about determining what the most important issues on workplace relations are to employers in small and medium businesses?
It was definitely a fairly rigorous process. CCIQ conducted numerous surveys and polls of its membership on various aspects of the Fair Work regime, and the results have really been essential in informing the overall direction of the blueprint by showing where the weight of employer sentiment lay on key areas of workplace relations.
So what you're saying is that CCIQ's workplace relations blueprint provides recommendations for change in those areas that SMEs have told CCIQ that are most crucial.
Yeah, you've got it in one, Michael. We want CCIQ's blueprint to give them a powerful voice on workplace relations. Listed here on the screen are some of the main policy areas that the blueprint addresses. They broadly encompass some of the most important issues that confront employers in their day-to-day operations or affect the business environment, and if addressed would provide real tangible change to their workplaces.
And so this blueprint, just to clarify for our listeners, will be available online for employers to read in detail at their leisure?
It will, Michael. I suppose what I want to do now is to take you briefly through some of the issues that CCIQ has focused on in the blueprint and highlight the path forward that we have recommended be taken in respect of them.
All right, well, with that in mind, let's jump right in. One of the common observations about the Fair Work Act is that it has driven up the cost of employment. Can you elaborate on this?
Well, Michael, just look at that figure there on the screen. Nearly half of employers surveyed by CCIQ reported that they had experienced a decrease in profitability since the Act's introduction. Now, this can be attributed partly to increases in minimum wages, a surge in the cost of modern award rates and conditions, and an expansion of the national employment standards.
One of the most common arguments we hear at CCIQ from some parts of the workplace relations debate is that employers are all about engaging in a race to the bottom on wages. So what do you have to say to that?
Oh, Michael, I think that most employers would tell you that that is absolutely not the case. Our survey data shows that in fact Queensland employers support the idea of a safety net, which is comprised of the national employment standards and the minimum wage. However, it is crucial that they remain sustainable and true to their conceptual role as a safety net, that is, a minimum set of protections to which all employers must adhere. We also recommend, as you can see in Recommendation 7, that more flexibility in the application of the NES should be introduced so that they can be consistent with the requirements of a modern workplace operating in a global 24/7 trading environment.
And just looking at Recommendation 1, I can see that it relates to changes in how annual changes to the minimum wages are decided. Can you elaborate on that a little?
Well, often high-level economic data fueled by the resources boom is used to justify a decision for an increase. But we think that this data often overshadows the real state of the economy for many businesses. On minimum wages, CCIQ recommends that changes be made to the process by which the Fair Work Commission's minimum wage panel goes about reviewing the national minimum wage and minimum award rates each year, so that it can take into account a greater range of factors in making its decision, including the circumstances of award-reliant industries. Employers will know that the current process has resulted in minimum and award wages increasing across the board every year since 2010, and that's without any tied productivity increases or offsets.
I imagine that those increases may have been particularly hard felt by some of Queensland's major industries, such as tourism and hospitality.
Michael, these industries are what we call award-reliant industries, and therefore increases to the minimum wage and award rates, which are also a source of minimum employee entitlements, can have a really immediate effect on the day-to-day financial operations of a business and can unfortunately make some really difficult staffing decisions.
just on modern awards, which I see is dealt with under Recommendation 6, CCIQ wants to see that the minimum conditions they contain reflect the specific circumstances and operating environment within relevant industries. Can you explain what you mean by that?
That's an important point. Part of the reason we have industry-specific awards is so that they can be tailored to the conditions of the industries they relate to.
So what you're saying is that some of the minimum conditions prescribed in modern awards have become unsuitable to the industry that they apply to?
Michael, that's true, and if you want an example, you need look no further than the current penalty rates regime. Many businesses trading outside of 9 to 5, Monday to Friday hours, standard hours, so-called, have been forced to close on Saturday nights, Sundays and public holidays. But for a number of businesses, a number of industries in Queensland, that's simply not an option. Weekends are often their busiest trading times, while many experience seasonal peaks and need staff right around the clock during certain times of the year.
So just for the benefit of our listeners, could you give us a practical solution that could potentially be implemented in this respect?
I certainly can, and it's one we have already received a lot of positive feedback on, and that's as simple as allowing normal rates to be payable for the first 5 shifts of a working week, with the 6th and 7th shifts attracting penalty rates.
Claire, that sounds like quite a common sense compromise, and indeed it leads us on to another issue for employers that we hear about, and that's the issue of flexibility. And I hear that it's been affected for the worse under the Fair Work Act.
Michael, let me tell you that the ability of employers to implement flexible working arrangements has been one of, if not the greatest casualty of the Fair Work Act. As I just mentioned, employers really need to be able to put in place arrangements that suit the requirements of their business.
So what are we here at CCIQ recommending in this respect?
Well, CCIQ's recommendations on flexibility focus on bringing back individual statutory contracts. You can see in the graph that more than half of employers surveyed supported a return to statutory contracts, subject of course to certain protections, which would allow them to negotiate some important conditions with employees on an individual contractual basis in accordance with the needs of their business.
That sounds like quite a reasonable change, but would I be correct in suggesting that individual contracts have become a fairly controversial issue for both sides of the political fence?
It really has, Michael, despite the fact that individual contracts have been part of the workplace relations landscape in this country since the 1990s. But CCIQ is about getting outcomes, and we know that mention of individual contracts, despite their usefulness, can make our politicians uncomfortable, to say the least.
So is there another option that CCIQ can pursue in this respect?
They are called individual flexibility arrangements, and they are already in the Act. Currently, they allow employers to negotiate certain arrangements with employees, but their take-up has been quite low because of the strict conditions around how they can be used. For example, they can't be offered as a condition of employment, and they can be unilaterally terminated by an employee with 28 days' notice.
And so CCIQ's alternative recommendation, I suppose, would be to relax some of these conditions.
Michael, we think that if IFAs could be offered as a condition of employment, allow trade-offs between financial and non-financial benefits, and the notice period for their termination could be extended, they'd be a much more useful tool in promoting flexibility.
Claire, just before we move on, you flagged earlier that the government was looking to tighten up laws around casual work, which they are now calling insecure work. Do you think that this could have some adverse consequences for employer flexibility?
Oh, Michael, I'm so glad you raised that. CCIQ recognises in the blueprint that casual working arrangements are at the heart of a number of Queensland industries. But the Prime Minister has recently announced her government's intention to legislate to entrench penalty rates for all employees working in casual and shift work. There's also been some talk of extending all of the national employment standards, including annual leave and redundancy pay, would you believe, to casual employees. This would simply make a number of Queensland businesses, a number of Queensland industries unviable, and overlooks the fact that many employees also seek flexibility in their working arrangements. I can tell you that CCIQ, through the blueprint and our general advocacy, will always work to ensure that casual working arrangements are protected.
Well said, Claire. Well, let's move on to an issue that affects every employer in Queensland and Australia, and situation?
I have absolutely no doubt that most of our listeners will be aware that the mandatory superannuation guarantee levy is going to increase from 9% to 12% on a phased-in basis over the next several years, beginning actually on the 1st of July this year when it goes up to 9.25%, and that they alone will bear the cost of this increase without any corollary offsets or productivity increases.
Claire, we hear a lot about the sustainability of our superannuation system. Is this a sustainable arrangement?
Well, no, we don't think that it's a good long-term proposition that employers continue to carry the bulk of the responsibility for employee retirement incomes. And you can see from the graph on the left that our data shows that nearly 40% of surveyed businesses believe that future increases to superannuation contributions should be funded by voluntary employee contributions. And that accords with the notion that we should all be taking some responsibility for our own retirement incomes.
So does the blueprint recommend that employees take greater responsibility for their own superannuation balance?
Well, it suggests that more needs to be done to increase employee awareness about the importance of building a retirement income, including by encouraging voluntary employee contributions. But Michael, where costs are borne by the employer, trade-offs in wage and productivity increases are really essential. And without such changes, I have to say that employers may, again, need to make some tough decisions. You can see here on the screen that nearly 2/3 of employers said that they will need to decrease employment levels as a result of the 3% increase to the mandatory levy.
Thanks, Claire. Well, just a reminder to our listeners that if you do have any questions about the content that we've covered so far, please type them into your message box and we will try and answer them all. And just with the questions, try and keep them as short and concise as possible so we can get through as many as possible. Claire, we have one question from Laura, and she says, when you say that minimum wage increases should be paid for by offsets and trade-offs, can you explain what you mean by that?
Sure, thanks for that question, Laura. Well, as you know, the 3% increase to the mandatory levy is being phased in over a period of several years, starting off with 0.25% a year and then moving up to 0.5% until the full 3% increase is implemented. What we suggest is that, for example, when the minimum wage panel meets each year to decide if there should be an increase to the national minimum wage and associated minimum award rates, that any increase should be offset by that year's increase to the superannuation levy. So, for example, if that year the superannuation levy is set to increase by 0.25% and the minimum wage panel decides that there should be a $10 a week increase to the national minimum wage, then that $10 should be decreased by 0.25% to account for that increase that employees will ultimately receive in their superannuation incomes.
Thanks, Claire. That's fantastic. We've got another question just before we move on from Nick, and he has said, if CCIQ is concerned about the increasing cost of superannuation for employers, then why aren't you pushing for mandatory employee contributions?
Well, Nick, thanks for that, and that's another good question. If you think back to the history of how mandatory superannuation came in Australia, it came as a result through the Accords in the early 90s, and basically superannuation was introduced as an alternative to increasing wages. So we do think that, and we also do think that there is merit in having employees essentially set aside some of their income, which would otherwise be paid as a wage increase, for their retirement incomes and to reduce pressure on pensions and the national expenses. However, we do take your point that employees should be taking more responsibility for their retirement incomes and that employers shouldn't have to carry the bulk of that responsibility. So we, in our blueprint, in the finer detail, we advocate some soft compulsion measures. So actually ensuring that employees' income actually does contribute a greater amount to their super funds unless they opt out of that. So we think that we've seen that those arrangements have been fairly effective in other countries, and we think that could work here.
Thank you very much, Claire. Just before we move on, all of our listeners, feel free to send through more questions as we go, and we'll touch back on that again shortly. We'll just move on to a fairly Andrew, unfair dismissal and general protections claims, these can prove quite expensive for small business, can't they?
Oh, they absolutely can, Michael, and because this is the case, we actually believe that an essential starting point is a total exemption from unfair dismissal claims for small businesses. We also recommend that the definition of a small business under the Act should be increased to include up to 49 employees, much more realistic number in our view.
And looking at CCIQ's recommendations on the screen there, it seems that the focus is really on restoring a balance to the employer-employee relationship. Is that correct?
Yeah, that's correct. Part of this is ensuring that employers, they don't have to go to the time and expense of defending themselves where baseless or vexatious claims are made against them, or worse still, pay go-away money. So we think that this could involve upping the application fees for making claims and putting in place cost penalties where claims have not been made in good faith.
Sounds like quite a sensible idea. I think most of us are clear on how unfair dismissal claims work, but can you tell us a little bit more about general protections claims? I mean, just looking at the graph in the centre there, there seems to be a consistently high number being made each quarter.
There is, Michael, and it goes to the fact that a burgeoning area of employer-employee disputes is arising from the general protections around unlawful dismissals as opposed to unfair dismissals. Now, these protections protect employees from employers who take what is called adverse action against them for a prohibited reason. So, for example, sacking an employee because they're a union member or because they're pregnant. The problem is that any employer who has such a claim made against them under the Act is immediately tasked with the burden of proving that the claim is untrue. Now, what does that mean? Well, it essentially reverses the usual onus of proof. This might explain why a consistently high number of claims are being made each quarter, as we can see in the graph that you referred to, and that's because it's just so easy for employers to do so. This puts, as you can imagine, an immense burden on employers in terms of time and money. And a key part of recommendation 5 up on the screen is that the burden of proof should reside with the person making the claim of adverse action.
So what you're saying is, I suppose, that these changes are necessary to ensure that claims with merit can proceed as appropriate, but equally to ensure that employers are still able to make those important decisions, such as having to let someone go or perhaps demoting a staff member where they have reasonable grounds?
Well, we certainly don't think that employers should be able to unfairly or unlawfully sack their employees. Not at all, Michael. But for the majority who do the right thing, the capacity to make decisions about staffing arrangement, it really goes to the heart of an employee's ability to run their workplace, and we don't consider that such decisions in the ordinary course of things should require the payment of go-away money, huge legal fees, or the interference of the Fair Work Commission.
Thanks, Claire. Just continuing on this theme of managerial prerogative, I understand that we at CCIQ are quite concerned by the increase in union activity in Queensland. Indeed, we've had a number of incidences occur out the front of CCIQ in the past, and this has all been since the introduction of the Fair Work Act.
Yes, CCIQ has received numerous visits from our friends in the union groups, but no, Michael, we are concerned about this increase in industrial action, and we know that many employers share this concern. And I guess it's because the problem is that industrial action, once started, is very difficult to stop under the Fair Work Act and can have a monumentally negative impact on a business. Often, the cause of the action is a result of unions seeking to bargain in respect of an issue that's unrelated to the employer-employee relationship.
Is there anything that can be done to stop the need for industrial action in the first place, Claire?
Well, there are quite a few things. CCIQ believes that it could be addressed by simplifying the negotiation and approval process for enterprise agreements. Now, this could be achieved by placing some more clear conditions on what are permitted matters for the purpose of an enterprise agreement. So, for example, the question of a business's corporate structure or their use of contract labour, they shouldn't really be a matter for negotiations and shouldn't be prescribed in enterprise agreements because they just don't relate to an employer's relationship with their employees. And just on that, we also recommend putting in place more stringent conditions on how industrial action, such as strike action, can occur.
Would I be correct in surmising that these recommendations aren't necessarily about penalising union members, but more about ensuring a harmonious working environment?
Oh, you've got it right, Michael. CCIQ, we support the right of employees to join unions and to actively participate as union members. Even if they want to do it outside our office, that's fine with us. However, we do not consider that unions should be seeking to interfere in matters that go beyond the employee-employer relationship or unnecessarily entering the workplace. To this end, we believe that there should be increased sanctions and penalties where unprotected or really what is essentially illegal industrial action takes place.
All right, well, just moving away from enterprise bargaining and industrial action, let's move on to some talk about apprentices and trainees. I understand that both anecdotal data from employers and official data show that commencements for apprenticeships and traineeships have significantly declined.
Unfortunately, that is the case, Michael. In the September quarter of last year, non-trade commencements fell from nearly 78,000 in the June quarter to just under 53,000 in the following quarter. You can also see the results of a CCIQ education and training survey up on the screen, and that showed that around a third of small businesses and nearly a fifth of medium-sized businesses, well, they'd never been involved in taking on an apprentice or trainee. Not only that, they had no intention of employing one over the next 3 years.
And does the CCIQ WR blueprint say anything as to why this might be the case, or how we can arrest this decline in employer training?
Well, there are quite a few reasons for why an employer might choose not to take on an employee in a training capacity, but one of the main ones that we canvass in the blueprint is that as unions seek what are really unrealistic hikes to pay and conditions for apprentices and trainees, employers are simply less able to provide these opportunities, particularly in what we call non-priority areas outside the resources and resource-adjacent sectors where business is just not booming.
So in light of that, do CCIQ recommendations take into account the two-speed economy that we are currently experiencing in Australia?
Well, I think it would be imprudent if they didn't, Michael. We want to see barriers to the commencement of apprenticeships and training removed by ensuring that wage costs remain sustainable and that a one-size-fits-all approach to apprentice and trainee wages and conditions across every industry and occupation is just not appropriate. I just want to add that CCIQ, we really strongly believe here that employers perform an important service by taking on a staff member in a training capacity, and it's essential that they continue to do so. This sort of on-the-job training is crucial to workforce development, and particularly in areas of Queensland, especially regional Queensland, that are experiencing some very pronounced skill shortages.
Indeed, it's something we hear quite a lot here at CCIQ. Thanks for that, Claire. Finally, we'll move on to the Work Act, which gives, I suppose, the Fair Work Ombudsman and the Fair Work Commission important roles in our current system. Is that correct?
It gives them a very big role, Michael. They are there to do things such as provide information to both employers and employees, police breaches of the Act, and make determinations on the interpretation of the Act. But Queensland employers have told us that they want to see both these bodies be more fair, efficient and effective in the performance of their roles.
Well, let's start with the Fair Work Ombudsman, in other words, the industrial watchdog. What issues do employers have in this regard, and what does CCIQ want to see occur?
Well, Michael, if you have a look at the screen, you can see that over a third of businesses told us that they had received confusing or conflicting advice from the Fair Work Ombudsman. And the most frequent example we receive of this here at CCIQ is where employers rely on incorrect advice from the Fair Work Ombudsman to their detriment. And many of our listeners will know that they just can't afford to see a lawyer each time that they have a question about their employment arrangements. And in any case, they shouldn't have to. CCIQ recommends changes to the operation of the Fair Work Ombudsman so it's able to provide prompt and accurate advice on details of the Fair Work legislation.
And what about the Fair Work Commission? That's the industrial tribunal, is that correct?
That is correct. Many employers were also unhappy about its approach to its duties, with a number of employers and managers telling us they feel it's weighted increasingly in favour of employees and that it's also becoming fairly interventionist in its approach. If you have another look at the screen, you can see from the graph on the bottom left that over 40% of businesses were dissatisfied with the Commission's handling of unfair dismissal claims. 38.5% were dissatisfied with its approach to industrial action and dispute resolution, and just under a third were displeased with the Commission's role in approving enterprise agreements or facilitating collective bargaining. Now, CCIQ's recommendation in this respect focuses on ensuring that the Commission better adheres to its role as an impartial quasi-judicial body, so sort of like a court, and operates in a more efficient manner where it is adjudicating on workplace disputes.
Thanks, Claire. We've had a couple of questions come in. We've got a good one from Angelo who asks, if I call the Fair Work Ombudsman about what award rate I need to pay a new staff member, and they advise me incorrectly, and as a result I underpay that staff member, do I have to pay them back?
Oh, Angelo, I hate to be the bearer of bad news, but unfortunately you will have to pay them back, pay for any wages that you've underpaid them, despite the fact that you've relied on advice from the Fair Work Ombudsman. The other side of the coin is that if you accidentally overpay them, they're not obliged to pay you back for the money you've overpaid them. So you can see that there's a little bit of imbalance in the system, and that employers are frustrated that where they do the right thing and they check the wage rates, that their good faith intentions aren't being rewarded.
Thanks, Claire. It's quite a sticky situation by the sounds of it. And we've got an interesting question that's come through from Deb. I would like to be able to offer my staff more flexible working hours. Maybe say that they can work 4 days, Monday to Friday, and then 1 day on the weekend to get their 38 hours. But I can't because of penalty rates. Do your recommendations on flexibility address these kind of problems?
Oh, thanks, Deb. I'm glad you asked that. I've been waiting for a question like that. So, as I mentioned earlier, employees also want flexibility in their working arrangements. And, for example, you might have a mother who wants to spend a day at home with her kids during the week, but is happy to work a day on the weekend. Unfortunately, however, a lot of employers can't offer those sorts of arrangements because they would then have to pay that employee penalty rates for working on the weekend. So you'll recall earlier I suggested that a potential option was, for example, allowing an employee to work for normal rates for the first 5 8-hour shifts of a given week. And then if they worked a 6 and 7 shifts, so you've got a really busy week, for example, then you pay them penalty rates. But you could organise for them to work those 4 shifts during the week and the 5th shift on the weekend as their ordinary hours, either through our rejigged IFA or through a statutory contract if they were brought back. So that would give both you and your employees some more flexibility in that regard. And that's what we're all about, finding some mutually acceptable solutions that will help both employers and employees.
Thanks, Claire. That's great. We've got a couple of good questions coming through, so I'll move on to our official Q&A segment, which has already begun. I've got a question that's come in from Karen. And Claire, it'd be great if you'd be able to attempt to answer this. In relation to the Ombudsman and Fair Work Commission, has the complexity of the Act and difficulty of interpretation encouraged the use of the no-win, no-fee option for legal action?
Let me just have a think about that. Well, I now take your point. So you're suggesting that employees are increasingly going to see workplace lawyers about issues that arise in the workplace. That's probably a very good point, especially with respect to issues such as unfair dismissal and general protections claims. They've become an increasingly litigious area with lawyers offering no-win, no-fee payment conditions for services in that regard, and that probably has contributed to a significant spike in the number of unfair dismissal and general protections claims. I would say, though, that there are some, in that respect, in regard to unfair dismissal and general protections claims, it's more the fact that those laws are so weighted in the employee's favour. So, for example, they have sort of fairly generous times to make their applications for the claims, and in the case of general protections, the onus is on the employer to refute those claims. So it's almost hard for an employee not to go away from one of those claims without some cash in their pocket, even where you as an employer may have felt that you had some very, very reasonable grounds for either letting them go or taking the action you did. So I can see that it's probably a mixture of both, but I think if the Fair Work Ombudsman, for example, was a more reliable body, then perhaps the employees could just get some simple information from them that might help resolve their issue without needing to resort to legal assistance.
That's great, thanks Claire. And just a note to Karen who asked that question, if you'd like an extension on the answer of this question, feel free to send it through to Claire via email at the end of the presentation. We've got a good question from Kath here. It's in relation to unions. It says unions appear preoccupied with creating disharmony in the workplace, and therefore it ultimately ends up in reducing productivity. What can CCIQ do to make for an appropriate balance where the employer is given a bit more support? And I think we've touched on this throughout the presentation as well.
We did touch on this a little bit, so I suppose there's a two-headed answer to that. On the one hand, you have issues with union entry. So currently, the capacity of unions or a union member to enter the workplace and, for example, ask to have a look at an employer's books to make sure that an employee is being paid properly, they can do this almost of their own volition without a request from a union member employee. What we're suggesting is that the ability for a union representative to enter a workplace must be strictly on the request of an employee who is a member of that particular union. They must seek the employer's permission to enter the workplace before doing so, and that the documents that they seek permission to view must strictly relate to the employer's relationship with the employee in question. The other side of the coin is industrial action. And as I mentioned before, industrial action can have a really dreadful effect on a business in terms of, the business finds it difficult to operate, people gain a negative perception of the business. You'll recall a fairly major example of this during the Qantas dispute when Qantas's name was dragged down into the mud during the prolonged periods of industrial action and sustained fairly significant economic damage. Unfortunately, smaller businesses can't quite accommodate economic loss to the same extent that businesses such as Qantas can. So that's why we have advocated that industrial action really should be an absolute last option when it comes to resolving employer-employee disputes, and that there should be a lot of other soft options in place to allow employers and employees to negotiate. And just before, I finish up, I would strongly emphasize that in workplaces where there are enterprise agreements, that those enterprise agreements should not contain terms and conditions that go beyond the employer-employee relationship. So as I mentioned, prescribing whether the employer can or cannot use contract labour.
That's great, Claire. Thank you. We've got a good question that's come in from Robert, and it says, are these recommendations that CCIQ is putting forward being submitted to the opposition party for their views, taking into account the upcoming election? And I suppose if I can lead you on that one, Claire, I know that we are actually preparing our blueprints to be sent to both sides of the political fence. Is that correct?
Oh, that's a great question. I actually spent yesterday drafting a letter, sending our blueprints out to all, I think it's about 220 federal parliamentarians, so that's opposition members, government members, independent members, I think the Green member. They will all receive a copy of our blueprint because we think it's really important that our parliamentarians, and it's our federal parliamentarians because they have the power to change the Fair Work Act, that they know what small and medium businesses not only need to run their business, but what they expect in the lead up to the 2013 election.
Thanks, Claire. We did have a question that came in from David, but I'm just going to say It says, do you have any recommendations relating to redundancy, specifically in relation to providing a clear definition to the term customary and ordinary turnover of labour? But Claire, I won't pass that question on to you. David, if you'd like to call our employer advice line to assist you with terminology and contract work within your own organisation, I think that's probably the best decision. Folks, that's just about all the time we have for our actual Q&A session today. I might just move on and wrap up our presentation. Claire, would I be right to say that there is not just one issue with the Fair Work regime, but rather it's the combined effect of problems with the Fair Work Act that we need to see dealt with?
Michael, I think that's exactly the case. Queensland employers, Australian employers, all employers, they can't afford the continued inaction on workplace relations, and they certainly cannot afford the cost of additional changes that the federal government has flagged for the Fair Work Act. However, equally at the same time, we know that they can't afford the cost of continued regulatory change in this area every time there is a change of government. Many of our listeners will know how long it takes to fully acquaint themselves with a new workplace relations system.
So what we're talking about here is long-term change, is that correct?
That's our strong intention. The recommendations in the blueprint are not about politics, but they represent the practical foundations of a workplace relations system that regulates when necessary, but doesn't seek to protect employees from the worst case of employer to the detriment of the majority of those who are out there doing the right thing. So I guess this blueprint represents CCIQ's understanding of how important workplace relations issues are to Queensland's SMEs, and clearly conveys our message on their behalf to the federal government and to the federal opposition for that matter, that change is urgently required.
And Claire, the question that we had previously from Robert goes to what I was going to say next. Actually, I think our listeners are eager to know how CCIQ is going to communicate these messages in the blueprint to our federal politicians, who are at the end of the day the decision makers.
Well, just to be clear, Michael, over the coming months, we'll be meeting with or writing to a range of stakeholders, including federal government ministers and shadow ministers, and really measuring their policies and commitments against what our recommendations seek. And along the way, CCIQ will definitely provide regular updates to members on progress we make in turning these recommendations into genuine outcomes for our members. We'll also be sending, as I alluded to earlier, a copy of the Workplace Relations Blueprint to all our federal parliamentarians, regardless of what side they sit on in the House of Reps or the Senate, to ensure that they know what Queensland's small and medium business community expects of them in September. And while the run-up to the federal election in September is a great opportunity to remember the importance of small and medium businesses to our economy, the blueprint and CCIQ's approach to it, for that matter, isn't based around empty rhetoric or promises or election cycles. CCIQ is always going to be here for you to seek a better environment for small and medium businesses.
Thank you very much for that, Claire. And I'd like to remind our listeners that the blueprint is available online at the address that you can see on your screen. Physical copies are also available from our regional managers and policy counsellors. If there are any questions that have been sent through and we haven't had a chance to answer today, we will follow those up in a response email. And please feel free to send through any more questions you might have to Claire at the email that you can see on your screen. On behalf of CCIQ, I'd like to thank Claire, and I'd also like to thank you, the listeners, for taking the time out of your busy day to participate and hear what CCIQ is doing for small and medium business in Queensland.